Start with American Safety versus Donald Griggs.
May it please the Court, Your Honors, I'm John Christie, along with Lester Keeney, representing the appellants in this case, who I'll collectively refer to as American Safety. I would like to reserve 5 minutes of my time for rebuttal.
Yes, sir.
Your Honors, this is an appeal taken from the Circuit Court of Volusia County denying a motion for directed verdict at the conclusion of a 4-day trial on a claim for unjust enrichment brought by the plaintiffs. The appellees would have this court, much like the trial court, be distracted by the citation to a slew of extraneous facts which are designed to evoke sympathy for the appellees, who in plain terms had made a bad investment with Herman Mac McMurray of the Harbor Village project and had lost their money at least 10 years before American Safety ever entered the picture. The court should not lose sight of the fact that after a 4-day trial, the only claim of the plaintiffs which survived was that for unjust enrichment. The facts upon which the appellees dwell, and which so we believe prejudice the trial court's thinking, leading it to make numerous erroneous findings of undisputed facts, were the basis of over 6 years of litigation between American Safety and Mr. McMurray. Each time those claims were decided in favor of American Safety, including twice in this court. The trial court made a critical error, in addition to its factual errors, a critical area of law when it found that a claim for unjust enrichment can exist when there exists an express contract on the same subject.
Is your argument that these documents show the assets as well as the liabilities and the apportionment of what is the anticipated assets from this project and what are the liabilities? That is, here's what we will do, here's what we will pay, here's our obligation, here is what we are expected to earn. And that defines what our liabilities are, and that defines what our expected profits are.
Well, I think, Your Honors, the plaintiff's case was originally premised on a profits and participation agreement that they had with Mr. McMurray, with Ponce Marina, not with American Safety, in which that was the express contract in which Mr. McMurray and his company agreed that they would pay monies that were originally an investment, later converted to a loan from the Connecticut 7, from the profits that Mr. McMurray obtained from the development of the Ponce Marina project. American Safety at all times was a lender that stepped into the shoes of an existing loan. It never had any obligation or relationship whatsoever with Connecticut 7 on a contractual basis. That obligation was between Mr. McMurray and his company and the Connecticut 7.
There was no contract between the Connecticut 7 and your clients.
That is correct, Your Honor.
How does that fit into your argument that there can't be quasi-contract if there's a contract, since the alleged quasi-contract is with your client and the Connecticut 7?
Well, Your Honor, there's the quasi-contract. Our position is that in the light of an express contract, which dealt with how the Connecticut 7 are going to be paid, that is from the profits, Mr. McMurray's profits from the project, it is inconsistent with that notion of an express contract for parties to be able to go behind that contract and create a separate independent basis of liability against a third party who had absolutely nothing to do with the obligation. Keep in mind, this debt for investment, Connecticut 7, was created in the 1980s, 10 years, over 10 years before American Safety ever got involved in this picture whatsoever. That was a debt that McMurray and his company owed the Connecticut 7, in which he entered into an agreement to repay them in a certain manner. That contract, the express contract, would be the equivalent of a real estate broker trying to sue the purchaser after the fact, claiming the purchaser got some sort of benefit from the sale just because the seller didn't pay the commission pursuant to an agreement. The Connecticut 7 are essentially trying to argue that American Safety somehow, as a lender, is now liable to them as Mr. McMurray's creditors. Such a finding would not only upset the law of express contract, but also real estate financing and foreclosure, since there would never be any finality to a real estate foreclosure if lenders have the potential of being liable to their borrowers' creditors. In this particular case, the trial court premised its finding of unjust enrichment on there being two benefits that went to American Safety.
Was there a finding that there was a relationship between the parties that would allow the court then to find that there was an obligation?
Your Honor, there's no confidential or other relationship between American Safety and Connecticut 7. During the entirety of all these transactions, they gave rise in May of 1998. The Connecticut 7 were represented by counsel. Mr. McMurray was represented by counsel. American Safety was represented by counsel. These were arm's-length transactions by parties who were represented by counsel, and a document, that purpose and participation agreement, was negotiated between all the parties, and it was an agreement that was reduced to writing, by which Mr. McMurray would repay the debt he owed to Connecticut 7. Now, the trial judge, we believe, excuse me, made a number of serious errors, basically errors of undisputed fact, which we believe colored and influenced the decision. For example,
was there any allegation in this case that the financial arrangement that brought your clients into this project was in some way a sham, some way a conspiracy with the prior owner, some kind of blending of interest between the prior owner, or is all the evidence that this was, that your folks came in on an arm's length transaction?
Your Honor, the evidence is that this was an arm's length transaction. There was an April 1998 commitment letter, which was introduced into evidence, which set forth the terms under which American Safety could purchase the existing mortgage, make additional advances to Mr. McMurray, and set certain conditions for making that loan. Loan agreements and documents were drafted and recorded, and this was strictly a loan that was ultimately foreclosed because Mr. McMurray was unsuccessful in being able to develop this property. Now, some of the errors of fact which we believe the trial court was influenced by, but which are undisputed facts, and this is important to keep in mind because the trial court's error and the trial court's order should be viewed with some skepticism, considering the fundamental errors of undisputed facts that were made. For example, in finding there was a benefit to American Safety, the trial court concluded that the list pendants that had been filed in 1994 had to be released in May of 1998. Well, the undisputed evidence was that list pendants was released in November of 1994. The trial court concluded that while saying in one part of its order that American Safety was purchasing the existing mortgage, it went on to say that Connecticut 7 had to release their 1994 agreement that had been recorded in order to give American Safety a superior mortgage lien. Well, that's not true because they succeeded to the existing first mortgage, which was already senior to any interest or claim of the Connecticut 7.
Would it have made any difference anyway? The mere fact that they had to release a lis pendens as part of the negotiation somehow turn it into an unjust enrichment claim?
It doesn't, Your Honor, because this was, American Safety said, this is the terms under which we will make this loan. But Connecticut 7 had their backs against the wall in May of 1998. This property was subject to a foreclosure by the then holder of the mortgage, N.D. Marina. It was subject to a tax sale. They were on the verge of being completely eliminated from any hope of seeing any money from this project. This was a Hail Mary. And American Safety, they didn't have to do it. They did not have to release the agreement. They did not have to release if they had not the list pendants. They did not have to release their lien on the stock. They could have said, no, we're not doing anything. They chose to give it one last shot to try to preserve whatever chance they may have ever had to be repaid by Mr. McMurray.
Isn't in there underlying in the final judgment a belief that there was collusion among the parties, and in that way, as an equitable result for the Connecticut 7, that the court wanted to grant them some relief because of the collusion?
Your Honor, I don't believe there was any evidence of collusion. I mean, I think that American Safety, the evidence is, I'm sorry.
I say that because it appears the court thought that the corporations were acting together in transferring the property, and that it was not an arm's length transaction.
Well, Your Honor, I think you're referring to the foreclosure. After the property was foreclosed in March of 1999, and after several unsuccessful efforts to sell the property, it was ultimately transferred to an American Safety subsidiary called Ponce Lighthouse, Inc. There was no evidence, I might add, at the trial, nor were there any allegations of alter ego, any ultra vires, which would create any basis for this joint.
Here's what the trial court found, and you tell me if I'm wrong. That the defendants acted concertedly at all times through identical officers, representatives, and attorneys in achieving benefits shared by the commonly owned companies, and then they seem to highlight the fact that American Safety demanded the concessions from plaintiffs indirectly through McMurray on the very eve of closing of the refinancing loan, and at a time that McMurray and TMI faced imminent foreclosure sale by the previous mortgagee. And therefore the court concluded that there was an equity that needed to be righted.
Well, Your Honor, that is an erroneous, clearly erroneous finding. If the court will examine the record in this case and look at the commitment letter that was dated of April of 1998, it specifically provides for, number one, a pledge of the stock. It provides that American Safety has to get a title commitment that is satisfactory to it. And it provides the other terms of the loan to Mr. McMurray. American Safety was saying to its borrower, look, borrower, these are the conditions under which we're going to make a loan. We can't satisfy them, we're not going to make a loan. You need to be able to satisfy these conditions. It's McMurray who approached the Connecticut 7 to tell them, I've got this loan, I've got these conditions. There's a letter in the record as well from counsel for the Connecticut 7, which confirms the terms of the Profits and Participation Agreement. We then have the Profits and Participation Agreement. There's no evidence there was any kind of bait and switch. There's no evidence, and I looked at the testimony of Mr. McMurray on this issue, transcript. There's no evidence that on the 11th hour, somehow American Safety said it wanted stock, or it wanted this, or it wanted that. That was in the deal from day one. There was no bait and switch. And clearly, the Connecticut 7 could have just said no. They were under no obligation to do anything. And if they had done nothing and the loan had not been made, the property would have been foreclosed by the other lender.
Now, do I correctly understand that the only defendants in this lawsuit were your related company?
Yes, sir.
McMurray wasn't in there. The company that held title wasn't in there. None of his companies were in there, correct?
The Connecticut 7 never in 15 years ever sued McMurray except once in 1994 to recover their debt. I might also add that these facts concerning the circumstances of the closing, concerning what happened after the closing, were subject to 6 years of litigation with Mr. McMurray, at which he lost at every turn.
So the conclusion by the trial judge in the final judgment about defendants acting in concert wasn't your folks acting with McMurray or any of his related acts. At most, it was some connection between your companies,
Correct.
all of which came in, if at all, through this one financial transaction.
Correct, Your Honor. It's inter se, if you will. But there's no basis, there's no evidence in the record that would substantiate this alter ego or joint liability. There's no allegation of any kind of alter ego, veil piercing, or any kind of theory that would lead to this joint liability by all these parties. But the key here, though, is this unjust enrichment. That's the only claim that survived. And that has to be looked at in the context of what happened in May of 1998.
What's your understanding of what the enrichment was that was being claimed by the plaintiff or found by the trial judge?
According to the trial court, there were two benefits that it found were conferred on American Safety. One was the release of the lien on the stock that the Connecticut 7, the stock in Ponce Marina Inc., the borrower, the Connecticut 7 held at the time. And two was the release of record of a November 1994 agreement by which they were going to get repaid by Mr. McMurray from profits of the property.
And that enrichment was valued by the trial court at the exact same number of what those folks had invested in the property originally?
And our position on that, Your Honors, is that there is no logical nexus between the two of those. And even in an unjust enrichment case, if this court were to find there was a direct benefit, that it was knowingly retained, that it was, in fact, unjust, which we contend it was not unjust for American Safety to retain it. There is no competent or credible evidence of the damages. There is no evidence of the value of the stock. There's no evidence as to the value of that agreement that was released. There is no logical nexus between the amount of debt that was low, the investment, started out as an investment, keep in mind, in the 1980s versus the release of those two interests in 1998. There's no basis to remand the case for that reason. Even if this court, keep in mind, this is an appeal from a directed verdict. This is not a situation in which the court had a record and applied the wrong legal standard. And therefore, this case could be remanded, and the trial judge, with direction from this court, could then compute the correct damages. This is a case in which there is an absence of any meaningful, credible, reliable, competent evidence to sustain the award of damages. And as a consequence, even if this court were to find there was unjust enrichment,
the dollar figure appeared to be unusual. Is there any contract to state that there would be liquidated damages of the amount of the investment or any agreement? It's simply that the court made the finding that that was the valuation?
Correct, Your Honor. The only document there is the Profits and Participation Agreement of May of 1998 between Mr. McMurray and Connecticut 7, which incidentally also even provides for discounts. If the Connecticut 7 are paid, if McMurray sells the property, you don't even have to pay back the full amount. In addition, that agreement contemplated that there was a mortgage in the property. The mortgage had to be paid before the Connecticut 7 would see any money, and further provided that if the mortgage holder objected, the Connecticut 7 might not even be paid. So clearly, the Connecticut 7 got what they bargained for.
So are you saying if this Hail Mary, as you call it, was successful, they wouldn't have come out as well as they did in this lawsuit?
Very possibly, because had McMurray sold the property under that profits and participation agreement, I believe the number is $1,750,000, they would have discounted that number down to. Had he sold it in certain ranges, there was a formula for determining the amounts that they would be repaid over time. And I'll say, if I have any questions, I'll save the balance of my time for rebuttal.
You have approximately 5 minutes.
May it please the Court, my name is David Bukelja. I'm here on behalf of 7 Connecticut businessmen referred to as the Connecticut 7 during the course of this litigation.
How is it that they, years later, can now say that we invested, we realized it was a risk investment because of the tumultuous relationship that they had with Mr. McMurray over the years, and now we want our investment back from an owner who was not involved in the negotiations or the contracts or the agreements?
It's simple, Your Honor. The trial judge, who sat there for 4 days and listened to this testimony and examined 81 exhibits, predicated liability on the misconduct of this lender. That's the basis of the liability here. And the reason they're liable for that, which counsel failed to point out, was at the point in time in which this transaction was entered into.
In 88?
Well, in 1985 is when McMurray bought the property. Around 1988 is when the Connecticut 7 put up $2.1 million as additional collateral. From 1980, I think it was the beginning of 1988 to 1989, that lender allowed McMurray to utilize that money to fund the project, and that was the single source of funding for the project from 88 through 89. You fast forward, and during this time frame, what we have is we have a lender who, of course, will not allow us to have a mortgage on the property because that violates their own mortgage. So what the Connecticut 7 does is the history from 1988 up through 1998 shows them engaging in every device they possibly can to secure their loan. Ultimately, over the course of that period, they end up getting assignments of stock in Ponce Marina Incorporated. They end up filing a declaratory judgment to try to establish some sort of an interest in the property, and as a result of that declaratory judgment action, they come away with an agreement in 1994 that's recorded of record. And what that agreement says is when we build these condos, you will get paid this amount of money over this period of time. And I emphasize that that agreement is recorded of record. Then we fast forward up to 1998 when American Safety arrives on the scene. Okay, the status is, yes, the property is in foreclosure, and McMurray is tapped out. The undisputed evidence is also that the property is appraised at $15 million at that point in time, and American Safety is acquiring an $8.6 million mortgage for $5.7. But as they get ready to go proceed, as they get ready for their closing, Leo Rose, American Safety's transaction attorney, determines, and this is a quote, determines that American Safety wants the stock that my clients hold. American Safety wants that agreement that's recorded of interest relinquished. Now,
At which point your clients have the option to either say we don't want the deal or we want the deal, right?
absolutely, Your Honor, they could have said,
And they chose to say we wanted the deal, we're willing to accept that circumstance.
they could have gone and acquired that mortgage without getting my client's stuff, and the converse to that is my clients could have said, no, we're not going to give it to you. So what happens next? American Safety, and this is the point that wasn't mentioned, American Safety says the carrot that they hold out to the Connecticut 7 is we will settle the foreclosure action.
Is that documented?
Yes, sir. It's right here in the profit participation agreement. This is the profit participation agreement that is prepared by American Safety. Now, mind you, American Safety orchestrates all of this. The dealings in the negotiation of this agreement were directly between American Safety's transaction, corporate counsel, and president with the Connecticut 7 group and their
So you have a contract with them.
So we have a contract.
So do you sue them on the contract?
No, sir.
Why
This
not?
contract is what we're left with as a result of this negotiation. Because as part of this agreement, we're going to return the stock, which we did. We're going to release that recorded agreement, which we did. We're not going to record this agreement, which was their requirement. And we're going to wait for payment until these units are sold. And why are we going to do that? Because whereas owner desires that American Safety Reinsurance Limited acquire the first mortgage loan and first mortgage loan documents and to provide further development and pre-construction financing to owner and to settle the litigation. The quid pro quo here, the bait and switch, which is what counsel referred to here, is the bad news is we were giving up whatever security we had to American Safety. The good news was the foreclosure action, which was the biggest threat to our...
But if there's going to be a loan, the lender wants to be secure. What is the problem with saying that we want the stock and we want all these other things to make sure that we're secure? The reason I would think the reason you didn't sue under that contract is you probably wouldn't have a measure of damages under that contract, would you?
American Safety is not a party to this agreement.
But the question was asked before, why didn't you sue under that contract? And you went through a litany of reasons as to why you didn't. And I thought from what you were discussing was the fact that that there wouldn't be a measure of damages under that contract. You're saying now that they weren't a party to it and they couldn't have sued under it anyway.
This agreement, orchestrated by American Safety, is between the Connecticut 7 and the then owner, Mr. McMurray. Mr. McMurray gets foreclosed out. I don't know what the legal term would be, but I suspect this is essentially a nullity.
But that agreement wouldn't allow you any damages anyway, would it?
As a practical matter, wouldn't allow us to recover any damages against McMurray once he's foreclosed out in the very foreclosure action that we're told is going to be settled when they ask us to relinquish our stock and our security.
So is your lawsuit on unjust enrichment based on that document alone?
This document is evidence of the unjust enrichment.
Well, here's the problem I'm having. What is the basis for you to say we are owed this amount of money? Is it that document that is the basis of the obligation to be paid?
We conferred a benefit upon American.
Well, question, what is the document or documents of record in this case that is the basis for you to be paid?
The conduct of American Safety, the inequitable conduct.
Well, assume you have a guy who's acting improperly. There has to be some documentation or some agreement to say we are owed money, pay us. Now, the person could be a jerk, but that's not a reason to get paid. What is the obligation? What is the document? What is the agreement that allows you to say you are owed money?
It would be, first off, the profit participation agreement is the result, if you will, of the representations and assurances. This is not the document.
Assume you were told a tale to get you to do something, to sign a document, to enter into a contract.
Yes, sir.
Assume you were induced into doing it. What is the ultimate document that gives you the basis to say we are owed money? The behavior led to something that caused you to be obligated to be paid.
The behavior led to us returning the stock, executing releases of the security that we had recorded, returning the promissory notes. Those are that's the consideration, if you will, that we relinquished at the request of American Safety when they promised us they would settle this litigation. Those are the benefits that we delivered.
Where is that memorialized? Is that the only document that memorializes
No,
the
sir.
negotiations that y'all had?
You have in the record the release of the stock pledges. You have the release of the security of the recorded the recorded November 1994 agreement. All those matters are in the record. So what we have is we continue. So the specific quid pro quo, as I mentioned.
So essentially what you're saying, you don't have a cause of action under that document that you're holding up. You don't have a cause of action under any other contractual agreement. So your cause of action is based on unjust enrichment. And under the theory that you put forth, the damages were calculated at some several $1 million.
Okay, well, let me back up. First off,
essentially, I mean, you concede that there is no written agreement that would provide you with a cause of action in this case?
well, I thought there was a written agreement that provided us a cause of action. That was an amended, restated profit participation agreement. At a point in
Now you're
time,
holding that up again.
that is not this document. At a point in time after this document is entered into,
What's the date of the document? Maybe that'll help.
October 2, 1998. In the amended, restated profit participation agreement, American Safety agreed to lend McMurray an additional $625,000. In return for that, McMurray, or American Safety, was going to receive 2/3 of the profits of the project. The amount of money or profit that was to be paid to McMurray was reduced from what it had been in a previous document. The reason it was reduced was spelled out in that document were a number of creditors who were going to be paid from the project. And among those creditors was the Connecticut group. Brought a cause of action on behalf of that, brought a cause of action as a third-party beneficiary under that contract. That was part of the claim that was brought before the trial court. Trial judge directed verdict on that. My point is, there were other
Sorry, the
documents.
Connecticut 7 brought an action for, as a third-party beneficiary of this October agreement? Is that what you said?
The subsequent October amended restated profit participation agreement. That's
And
right.
that was rejected by the trial
That was
court?
rejected by the
And is
trial
not the subject of any cross-appeal in this case, correct?
No, sir.
Okay, so there was a contract on which you contended you had a basis of a claim against American Safety.
There was a contract in which I claimed I had another basis of a claim against American Safety. Yes, sir.
Does that preclude you from having a quasi-contract claim if you have a contract claim, or you assert you have a contract?
Well, according to the court, in directing verdict, we weren't a third-party beneficiary under that contract to begin with.
Under
So
which
the-
one?
Pardon?
Under which contract?
The amended, restated,
22nd of October.
the subsequent amended, restated profit participation agreement. So so there's documentation indicating that we were supposed to be paid. Court wasn't satisfied that we were a third-party beneficiary.
Explain to me what you say was the misconduct by American Safety.
American Safety told my clients, if you give us the security, which their transaction attorney testified to the significance of their having, that we will settle the pending foreclosure suit.
And they didn't settle the pending foreclosure suit?
Within hours of having received everything we were supposed to deliver, because our closing was supposed to take place before theirs, they then proceed to closing with McMurray, and at that point in time, McMurray is presented with a settlement agreement that does not settle, as the term, as my clients understood it would be, the litigation at all. It divests McMurray of...
Why isn't your cause of action then either a claim for a breach of an oral contract or a claim for fraudulent inducement into giving up your stock? I don't understand why it becomes a quasi-contract unjust enrichment claim.
Because it seems to me that all of those elements are subsumed into this unjust enrichment claim. We have benefits that they wanted. We had benefits...
But your position is they agreed to do something with you and then they didn't do it, right?
My position is they basically defrauded us because...
Okay, so why isn't your action for fraud, or why isn't your action for breach of an oral contract?
Because I don't know that that doesn't also qualify as the type of inequitable conduct.
Well, isn't there a rule that says you can't get quasi-contract if there's a contract? Isn't that a principle of law that you can't sue in quasi-contract if there's a contract?
It may be, Your Honor. We had no written agreement with American Safety.
I don't care whether it's written or not. Isn't the general principle of law you can't sue in quasi-contract if you have a contract?
I don't know, Your Honor. I don't know.
So, and it's your position that you had an oral contract, correct?
It's my position that we were misled into relinquishing our
Is
security.
it your position that they entered into an oral contract with you?
Your Honor, this document in and of itself very carefully excludes American Safety as a contracting party. Very carefully
But
excludes.
I understood you to say their misconduct was they agreed with you to take care of the foreclosure suit and then they didn't take care of the foreclosure suit. Is
As
that
they
correct?
said, as they specified right in this document, which
Why?
they drafted.
I don't understand why that doesn't support a claim for a breach of oral contract or for fraudulent inducement.
Perhaps it could, Your Honor, but at the same time, like I said, the elements of unjust enrichment are benefits derived, benefits delivered.
What were the benefits that were delivered and how were they valued?
The benefits were delivered with the stock. According to Leo Rose, under his testimony, it would be advantageous for American Safety to have the stock.
Was there evidence that the stock that was delivered was worth $2.1 million?
The determination as to what the value was.
Was there evidence that the stock that was delivered was worth $2.1 million?
No, sir. The evidence was that the underlying indebtedness for which the security had been obtained was at least $2.1 million. In fact, under this agreement...
All right, but I'm trying to determine what you say the benefits were and how much each of them was worth. You said One of the benefits was we delivered the stock to them. What was the stock worth?
I don't know what the stock was worth.
Was there any evidence what the stock was worth?
Yes, there was evidence what the stock was worth.
What was the evidence that what the stock was worth?
The amount of the amount loaned by the Connecticut 7, because the law under restitution says if you deprive somebody of their security, the amount of the damages is the measure of the underlying debt. And the underlying debt in this instance was a minimum of $2.1 million. I would have, and did argue at trial, it should have been the $3.5 million. It was specified in the parties' agreement. But the court may have come to the conclusion that the additional interest and what have you that had accrued on that $2.1 million wasn't a proper element of the value of the benefit.
When was the first time that they learned that a demand was going to be made upon them to relinquish their stock and their collateral, or their interest in the property, in exchange for the loan?
It was several days before the closing.
Several days?
I'm sorry, the day before the loan closing. The day before the loan closing, American Safety's General Counsel Fred Pinckney advised Ponce Marina's attorneys the Connecticut 7 had a lien on the title that had to be removed.
Wasn't there a letter from Fogel that indicated before that that they were aware of the fact that this was going to be a requirement or not?
There may have been, Your Honor.
It seems to me Mr. McMurray basically testified that there was an ambush here, and that all of this was sprung at the last minute, and that's why I asked the question. And it seems to me like the court may have put a lot of emphasis on that testimony about the ambush. It was sprung at the last minute, and they didn't know anything about it. When there may be evidence in the record to indicate that they knew, sometime before.
Okay, my recollection was it was a couple days before. That was my recollection. And let me comment in passing on Mr. McMurray and all the talk that I've heard of all of his lawsuits. Mr. McMurray signed a release that was the death knell of his lawsuits. I don't want this court left with the impression that there should be some inference that the McMurray facts and circumstances somehow spill over into this proceeding. Continuing on, with regard to the findings...
Let me ask you this.
Yes, sir.
As to the various defendants that were all found liable on this judgment, what was the theory under which you made claim against all of the defendants? Was this an alter ego theory? Was this a piercing the corporate veil? Was this a co-conspiracy? Explain to me how you got all of those entities into the case.
Because they all acted in concert. The evidence presented at trial was American Safety Insurance Group, parent corporation. The president was Mr. Fox. Mr. Fox was also president of every downstream subsidiary, such as Synergy, the entity that issued the commitment, American Safety Reinsurance Limited, the entity that made the loan. They then formed, after they foreclosed, they formed Ponce Lighthouse.
Also, the testimony that each was a separate legal entity and had counsel, and even though there was some overlap, they operated separately?
No, sir, there wasn't.
Was there any testimony to show that there was collusion or a concert of those officers of the different organizations to reach a nefarious result?
Yes, sir. There was the testimony from Mr. Fox from the American Safety Insurance Group Executive Committee talking about how they were going to remove McMurray and put Sarang in and have him run the project. There was the testimony regarding how...
Well, he had not been doing well. The fact that he was removed, this project had been going on for over 12 years. So is that the sole basis for determining that there was some act in concert of those organizations?
No, sir. There was a litany of testimony. There was extensive testimony. You have the same executives. You have the same directors.
Well, but you're not, as I understand it, you're not going on piercing the corporate veil or alter ego, correct?
No, sir.
You're going on collusion. So the fact that there's interlocking directors in and of itself wouldn't matter. It's what they actually did.
The basis of the liability was that they all acted in concert.
Not that they were alter egos of each other, not that they were sham entities, but that they each acted in collusion.
They each acted with one another, performing separate functions along the way for the purpose of obtaining the benefits they wanted from my
Well, don't you then have to show, in essence, a conspiracy among these parties? What evidence did you present to support your theory, other than they acted in behaviors that was best for their corporate entity? That is, to make a profit. But you haven't shown that there was anything going on between them that would lead to some kind of nefarious outcome. All you've said is that they did these acts, which are good business practices.
First off, this is a lender that we're talking about who's interfering with its borrower's business, and specifically a lender who has circumvented the borrower to go deal directly with one of its creditors. And in the process, that lender then picks and chooses various downstream subsidiaries and other subsidiaries for the purpose of performing various functions along its path, if you will, to obtain what it ultimately wants. Mr. Fox was the president of 4 different corporations here, all to which he assigned specific little tasks along the way. One was going to issue the commitment letter. One was going to make the loan. We're going to form a new one to build the company, to build the condominium. We're going to form another one to construct the company. The company that's building it doesn't have any money, so this company over here of ours will give them their money, and this company is going to receive title to the property that they never paid a dime for.
Let me ask, you made reference to a release that was given to Mr. McMurray. Did that release shield Mr. McMurray from any and all claims by the Connecticut 7 and everybody else?
I'm sorry, the release I'm referring to is a release that American Safety had obtained from Mr. McMurray.
Okay.
That defeated his claims against American Safety.
I'm still a bit concerned. Mr. McMurray, I think, gave testimony in this case that I thought, the trial court may have relied on, at least to a pretty great extent, I think. And so, I think you said before, or maybe I misunderstood, that you wanted to dissuade us from any notion that Mr. McMurray was biased or prejudiced, given the fact that, there may be some liability on his part with the Connecticut 7, and I thought you indicated that there was a release, but there's no release that shields him from liability from them, is there?
Okay. No, sir.
Okay.
And perhaps I misspoke.
I may have misunderstood you, but I thought that's what you were telling us.
My comment was that the outcome of Mr. McMurray's claim shouldn't have any influence on this particular case. That was my only point there. The release that I'm referring to.
Doesn't Mr. McMurray have an interest in shifting liability over to somebody else and kind of clearing the way for him? I mean, he testified that this was an ambush and it was all put together, and there was collusion and there was all this wrongdoing. He testified to that, didn't he?
Yes, sir.
All right, and
I'm sure he has no love lost for American Safety.
Well, the first thought that crossed my mind is he would have an interest in doing that, given the fact that he may have some liability to all these other parties, and if these parties were satisfied with the judgment against them, then they leave him alone. Is that not?
And I can only assume that the trial judge, while he was eyeballing Mr. McMurray sitting there in that witness stand, thought the same thing himself.
You've exhausted your time. Thank you.
All right.
Yes, sir. Thank you.
You have a total of 8 minutes. You went over an additional 3 minutes responding to the court.
Okay, thank you, Your Honor. I wanted to follow up on a few things that occurred during Mr. Volkelder's argument. As Judge Palmer noted, this is not a case of fraud and inducement. Mr. Volkelder recites facts. He relies on facts which may support claims had he brought them. But the only claim we're talking about here today is one for unjust enrichment.
What were his other claims that got dismissed by the trial court?
One was for constructive trust. He sought to, based on the profits and participation agreement executed in May of 1998, Connecticut 7 sought to impose a constructive trust on proceeds from the sale of condominium units. A summary judgment was granted on that claim. The next claim was one for enterprise liability. His argument was that the American Safety entities were successor obligors to Mr. McMurray, that by virtue of all these factual allegations that he's made concerning the operation and management of the property after the closing and the involvement of American Safety, somehow they, through a theory of enterprise liability, became Mr. McMurray, and therefore they owed directly to Connecticut 7 the money that Mr. McMurray owed. Directed verdict was granted on that claim. And the claim for third-party beneficiary that Mr. Volkelder was speaking about was a claim based on a profits and participation agreement not involving the Connecticut 7, but involving American Safety and Mr. McMurray and Ponce Marina. It was entered into in October of 1998. Directed verdict was granted on that claim. So of the 4 claims, the only one which survived was this claim for...
No breach of oral contract claim?
No, sir.
No fraudulent inducement or
No, sir.
fraud claim?
No, sir.
Okay.
Wouldn't you say that he really didn't have a contract claim to begin with? I mean, he didn't have a contract claim, did he? Oral or written?
The only contract claim he had was with Mr. McMurray.
Yeah,
But not with American Safety.
Okay, that's my question. I mean, there was no contract claim that he could have asserted against your client, is there?
No, sir.
It's not, so if that's the case, it's not that this is an inappropriate cause of action, it's just that it wasn't, from your perspective, it just that it wasn't proven. That there's no evidence to show that, that there was any unjust enrichment, and there's no evidence to show that any of the elements of that cause of action had been established. Isn't that correct?
Yes and no. The first way I would answer that is to say that there was a contract, and that was between McMurray. He had an obligation, and that was the deal. That was the negotiated deal at arm's length, and we can't create another deal to supplant the first deal. That was the deal he cut, good, bad, or indifferent. Secondly, even if there was a claim for unjust enrichment stated, there was no direct benefit. If American Safety received an indirect benefit from the release of the stock, again, they asked it of their borrower, Ponce Marina. From the release of the stock or the release of the November 94 agreement, it was not a direct benefit. Then there's the question of whether or not it's inequitable or unfair to retain that benefit, assuming that was a benefit. And the answer to that is no. A lender can require its borrower to put any conditions on a loan. And again, this was a negotiated, highly negotiated transaction by parties who were all represented by counsel during this transaction. If the law were any different, any mortgage lender who goes to their borrower and says, we got to have...
What happened, his basic claim is that they promised to settle the foreclosure suit in exchange for release of all this collateral, and they didn't do it. And because they didn't do it, they suffered all these damages. And without that promise, they wouldn't have relinquished anything. And so I'm a little bit fuzzy as to what happened there. And did they make that promise, and why didn't they carry through with it?
Well, number one, if there was a cause of action, it would be fraud and inducement. They would seek to set aside the agreement, this profits and participation agreement, get their lien back on the stock, put them in the position they were in prior to being fraudulently induced and entering the agreement. It doesn't create a situation of unjust enrichment, kind of apples and oranges. Secondly, I would say there's not evidence to that effect. I would commend to the court the testimony of Mr.
That's
McMurray.
basically my question. I forget whether the cause of action is right or wrong. Did they make that promise, and essentially what happened to prevent them from carrying through with it?
The answer is no. Mr. McMurray's testimony, which you have to assume is going to be the most favorable for the plaintiffs, because none of the plaintiffs other than Mr. Griggs testified. No other plaintiff testified from. Mr. McMurray doesn't say that, yes, we had a conversation with Connecticut 7, and they were told this lawsuit was going to be dismissed. And that's critical, because in this document that they're relying on, where they get this notion of settle and resolve, is not American Safety said it, because that's not in the record. They get it from the profits and participation agreement, which says that the litigation is going to be settled. And this is an agreement.
Okay, that's between McMurray and
Connecticut 7. And they were both sides represented by lawyers in that transaction. So this is not a situation in which there's an incompetent or an infant or an incapacitated person who's being taken advantage of. These were sophisticated businessmen represented by real lawyers who were advocating for them and representing their interests.
Can you give me a brief description of these four defendants and how they each play into this transaction?
Defendants, sir?
Yeah, your four clients.
Okay.
What's the relationship between, I'm trying to figure out how each of them played in this transaction.
Okay, well, if I get the, Ponce Lighthouse Properties, Inc. was a Florida corporation that was formed after the foreclosure in May of 1999 to take title of the property. American Safety had tried to sell the property, had tried to do something with it unsuccessfully, and therefore had to develop it, and ultimately did, and transferred the property to Ponce Lighthouse.
That's after the foreclosure sale, after they took title.
Correct.
Okay. And American Safety is the one that took title to it?
American Safety.
Originally at the foreclosure?
I believe it was American, and Your Honor, I could give the court the accurate information, because I believe it was American Safety Reinsurance Ltd. ASRE, which took title because it was ultimately the lender. So I believe it was the entity that actually took title of the property. American Safety Insurance Services, Inc. was formerly known as Synergy Insurance Services, which was the name change. It was involved in the issuance of the original commitment for the loan. And the loan commitment did say it would be made by a designee of Synergy intermediaries. And then American Safety Insurance Group Ltd. is another American Safety entity that's involved in the insurance business. I believe that may be the holding company, if I get these names.
When did the Connecticut 7 first become aware of the fact that this was going to be a requirement that they relinquish their interest in collateral? Do you know?
I believe was over 2 weeks before the closing. Don't forget, the original commitment.
Is that the Fogel letter that I was referring to?
Yes, Your Honor. There's a Fogel letter where Mr. Fogel outlines these terms, and keep in mind, you had an imminent foreclosure and tax sale. The first commitment from American Safety is issued on April 16th, I believe it is, 1998, and this loan closes on the 28th. There's not a lot of time that intervenes between when American Safety makes its loan commitment and the actual closing. But clearly, Mr. Fogel, there were telephone conversations. It was not, the document itself was telecopied around and signed by everybody the day before, the Profits and Participation Agreement. But the terms of that Profits and Participation Agreement were under discussion for some time.
About 2 weeks before?
Yes, sir. Your Honor, just in brief summary, there is no evidence in this particular case to substantiate any verdict. And this directed verdict should have been granted simply on the failure of the plaintiff to have proven any evidence. I think under questioning, Mr. Volkett was unable to point to any competent evidence in the record to sustain the verdict. He refers to Section 153 of the Restatement of Restitution, but it's a completely inappropriate citation. That's a citation which essentially says if A, through fraudulent conduct, induces person B to pay a debt owed by A to C, then B can collect from A. The Connecticut 7 never paid any debt of American Safety. It never discharged an obligation or lien of American Safety. So that his theory of restitution is somehow their loan or investment of 15 years earlier equates the benefit American Safety allegedly received is just simply unfounded, and there's no logical basis for that suggestion, and the citation to the restatement does not support for that contention. Moreover, the notion of any quasi-contract remedy here, as I said, is foreclosed by the existence of the express contract. Moreover, there's no evidence of any direct benefit that went to American Safety. Connecticut 7 got the deal they made. They got the benefit of their bargain. What they're seeking to do now is hold someone else liable for the debt that's owed to them by Mr. McMurray. The trial court should have granted a directed verdict on this claim. We ask the court to reverse and enter judgment for American Safety.
Thank you, sir.
Thank you, Your Honor.
Well argued on both sides.